Under the glow of streetlights in suburban Philadelphia, 23-year-old Kada Scott vanished without a trace. The radiant nursing assistant and aspiring Miss USA hopeful had just finished her shift when she disappeared. Her car still parked, her phone left behind. For days, her family pleaded for answers, hope clinging to every lead. Then came the break. Police arrested 21-year-old Keon King, now accused of kidnapping. Investigators say surveillance footage and cell data traced King's path to an abandoned school where they believe he left chilling evidence behind. And now, a huge development in the case. Kada's body has been found and positively identified. Tonight, new information about what happened to Kada and what is next in this ongoing investigation. I'm Vinny Politan. Thank you for joining us tonight here on Closing Arguments. This story is really upsetting, but it gets more upsetting when you hear more of the backstory. And the backstory tonight begins with the elected DA in Philadelphia. His name is Larry Krasner. He's a brilliant guy. He's a Stanford Law School graduate, was out at Stanford when I was there. I was an undergrad. He was in law school with my brother. Didn't know him, but smart guy. Everything he does, he knows what he's doing. It's not like he's oblivious to the impact of his decisions and his actions. And when he ran successfully, more than once, for Philadelphia DA, part of his premise of his campaign was to reform the system. Meaning we're going to change the way that we prosecute people. Because that's part of a DA's job. Reform the system, change the way we're doing it. We're going to rethink this. We need to reform the DA's office. Now, if you look at his background, before becoming a prosecutor, he was a defense attorney. Defense attorneys and prosecutors, completely different jobs. Completely different jobs, number one. Number two, that's an interesting background. It can be a great background to become a prosecutor because you know how the other side thinks. You understand the issues that the other side is dealing with, and now you're in charge of the DA's office. The problem is if you become a prosecutor with a defense attorney's mentality and a defense attorney's priorities. Now, the priorities of being a DA are pretty clear. As a matter of fact, if you look on the website for the Philadelphia DA's office, like the first thing they talk about is protect the community. Now, I don't know, is that a phrase that's up for interpretation? Like, how do you protect the community as a prosecutor? You enforce the laws. You enforce the laws. You prosecute the guilty. You prosecute the dangerous. You do what you can to remove the dangerous people from the community. We have a means to do that. We have things called jails and prisons. They are there to protect the community, which is job number one in the description of the Philadelphia DA's office. Now, whether you ran on reforming, your job is to protect. And if the two conflict, well, guess what should win? Protecting the community, enforcing the laws. A DA is part of law enforcement. They give you a badge. And it's not a participation badge. It's like a badge. You're a part of law enforcement. You're in charge, for goodness sake, of law enforcement in your jurisdiction. Larry Krasner and his office failed to protect Kada. Failed in their first job. This was a guy who was on the radar, not only on the radar, but twice had done something similar and violent to another woman. One of those attacks was caught on video. And the case was dismissed by the prosecutor. Dismissed because the victim didn't show up. It was domestic domestic violence. This is domestic violence 101. Victims don't generally show up. You have to understand the mindset of the victim in order to protect the victim and others in the community. Total failure. There's a way to prosecute a case when you have a non-compliant domestic violence victim. You have their statement. You take their statement. You subpoena them. You bring an officer down there to bring them to court. And then you provide any protection that they may need or they feel that they need. Wasn't done here. We're going to talk more about that, but let's talk about the latest updates now in the case and the results now that we know how much of a failure this was, because now we have confirmed that Kada Scott is in fact deceased. And that prosecutor, Larry Krasner, and one of his assistants brought the news today. Let's take a look.
It has been confirmed that these are the human remains of Kada Scott, and that has been confirmed by DNA.
As of last night, our office approved charges, as the DA just said, of arson, causing catastrophe, conspiracy, unauthorized use of an automobile, tampering with evidence, recklessly endangering another person, and receipt of stolen property. Those charges are in reference to the burning of a vehicle. That vehicle is a 2008 black Hyundai Accent. That vehicle first entered our radar last week. Investigators received a tip that there was a vehicle burning and that vehicle had some connection to this case. At the time last week, when investigators went to the location where the vehicle was burned, that vehicle was no longer there. It had already been towed, compacted, and was at a junkyard. This weekend, we recovered additional evidence, including video evidence that confirms that this vehicle, we believe, is the vehicle that Mr. Keon King used to move Ms. Scott. We recovered video out from near the Ada Lewis Middle School, where our search and the investigator search has been focused. There's a rec center directly next to that school. Video evidence was recovered from that rec center, and we are now able to say that this Hyundai Accent was on location at all of the times we're looking at all of the pertinent points in the investigation. That vehicle was stolen on October 3rd from the area of 6600 Sprague Street. We believe that vehicle is the vehicle that was used in this case. That vehicle was then on scene at that rec center, which ultimately, as we all know, is where we found Ms. Scott's human remains. Video evidence indicates it was on location. Video evidence then indicates it leaves the location. It is burned on October 7th. It was located at the 2300 block of 74th Avenue. When this new video evidence was uncovered this weekend, investigators from the homicide unit cross-referenced all of this information with the cell phone evidence that we had already gained and we had already been using in terms of the kidnapping case and other charges. What I can share is that the cell phone evidence, the call detail records, and timing advance data as it pertains to Keon King's mobile device puts him at all of the locations that we're talking about. It's on scene when the Hyundai Accent is there at the recreation center. It is on scene when the vehicle is burned. Based on that, last night I approved those charges, and as the DA said, we should have more information in terms of bail and a preliminary hearing date. Hopefully this afternoon or certainly by tomorrow. Last week we received a tip to go to the Ada Lewis Middle School. Investigators did a thorough search. Essentially what the new tip was this weekend was go back. It was go back, she's there, look again, and they did give more specific details in terms of where to look. And ultimately that is what led us to her.
That's interesting too, a little factoid there, a little footnote. We got a tip last week to go there, and we didn't find anything. Then we got another tip saying, hey, look harder, and maybe some more specifics involved there. That's a little troubling as well. All right, let's bring in our think tank. Joining us tonight, criminal defense attorney, former prosecutor Al Wunsch III, criminal defense attorney Darnell Crosland, and family law attorney Jennifer Brandt. Great to have everyone here. I want to begin our discussion and start focused here on the case that prosecutors have now and what they'll be doing next and why he's not charged with murder yet. before we get to all the other problems. We'll do that in the next segment, all the problems that I have with this DA. But let's start with you, Al. Let's talk about where we are right now in this investigation in terms of moving towards a murder case. Why do you think they're waiting? Is it the autopsy? Is it the toxicology? They want cause and manner, and then they just put 2 and 2 together here because they've got the abduction already, and they've got all this data, this location data.
That's right. They already have the kidnapping charge, which is a very, very serious charge, obviously. So why not wait to have all your ducks in a row before you go to the big number, which is the murder charge? And he's not going anywhere. I mean, like, he's this charge, the kidnapping in and of itself is going to be enough to hold him at any point in time. So there's no rush to get that charge. Do it right, sift through everything, have all your ducks in a row, have everything set up, and then go forward with the murder charge. That's the key in this, and that's what they're going to do.
All right, hey, Al or Darnell, what do you think here? The way it's progressing, this seems a little bit more normal at this point, right? If you've got a murder case, but you've got other charges that you can hold them on, you do that first. I'm just wondering how confident you are in them continuing this investigation to put the pieces together here. Darnell, we can't hear you. I think you're muted. There you go.
Yes, Al's upset that I unmuted myself. Sorry about that, Al. So the first thing we worry about is the is the safety of the community. So if you can, as we've seen in these cases, arrest someone, make sure that the community is now safe as you proceed with your investigation. That's the first thing that you do. It's but for a matter of time before the murder charge comes, because everything else puts him at the time and place of the murder. And we know that they have confirmed there is a murder, but as you said, we're going to get cause and manner, which are things that we have to do. And the last thing along that same line is that you don't want to rush a murder charge and have jeopardy attached in any way, because you arrested someone for a charge like that without probable cause, or give the defense attorney anything that they can hang their hat on. And speaking of that, as you stated in the opener, the DA, who used to be a defense attorney, is probably coming under some scrutiny for not doing enough to act like a prosecutor. So to answer your question, whether in fact we're going to get a murder charge, it depends. If he keeps the same routine, then maybe not. He might find a way to let this guy out. But if he puts on his prosecutor's hat and digs in, then we should have a murder charge coming soon.
Jennifer Brandt, this is close to your neck of the woods. I'm sure there's a lot of local pressure on him. I want to put a map up on the screen so we can see the area that we're talking about here. The original searches were in the Arboretum, which is the forested area here. You see where the abandoned middle school is and the rec center that was referenced. It just doesn't seem like a vast area that needed to be searched. Are you surprised, Jennifer? Are you disappointed that the original search didn't turn anything up? They had to have the tipster recall them and say, no, this time really look for her?
Yeah, I mean, it is upsetting to hear that, Vinny, because, there are a lot of trees in the area. There's an arboretum there, but...
Well, maybe it's a lot of trees for a city, but like for those of us in Georgia, that's not a lot of trees. Like, let's be honest. Like it's like two or three square blocks of trees. Like, it's not a forest. We're not out in the middle of this protected land somewhere. It's 3 square blocks in a city.
Well, I mean, Vinny, first of all, they didn't know exactly where she was, but until they got the tip. But it is upsetting to hear that they were generally in that area. They were around this middle school. They did search the area, but they didn't find her. And, other people have said that the grave area was, it was pretty evident that a grave was there. The earth was overturned. It looked like someone had dug something up. And so, why the police didn't see it, or what was going on, or did they not have enough people out there looking? I mean, these are all questions that they're going to have to ask. To your point, Vinny, there is a lot of attention, local attention on this case, and now national attention. I mean, here we are talking about it on court TV. So in terms of, watching what's going on from here on in, I think we're going to see, a lot of focus on this, and everyone, taking great pains to make sure that if this was a homicide, which we believe it is, that the person is convicted and some justice is served for Kada Scott and her family.
Absolutely. All right. Think Tank staying with us. When we come back, we're going to talk about Keon King, the suspect's prior history, and what the DA did not do and did do in those cases, plus coming up next hour. Tonight on Vinnie Politan Investigates, when children commit unthinkable acts, should the law see them as killers or as kids who lost their way? Across the country, prosecutors are torn between punishment and mercy. What should happen to young minors committing major crimes? Tonight, we investigate.
I've committed so many horrific acts over and over and over.
Do you think you deserve to die for murdering those innocent people?
You tell me. I wish more than anything, David, that I would have done something other than the things I've done in my life.
Are you really a changed man, or is this some kind of stunt?
Interview with a Killer, 2-hour season premiere, Saturday night at 8 Eastern and Pacific, only on Court TV.
It is with profound sadness that we share the tragic passing of our beloved daughter, Kada Scott. We kindly ask for space and privacy at this time as we process the heartbreaking events of the past few weeks. Our hearts are shattered, yet we are deeply grateful for the outpouring of love, support, and prayers from people across the nation and around the world. Please continue to keep us in prayer as we navigate this unimaginable loss. Our hearts are broken beyond measure. We are profoundly thankful to every person who shared Kada's story, joined the search efforts, prayed with us, and stood by our family during this devastating time. Your compassion, love, and strength have carried us when we could not carry ourselves. Kada was deeply, deeply loved. Her light, kindness, and beautiful spirit will forever remain in our hearts. We also wish to extend our heartfelt gratitude to Mayor Sherelle Parker, the Philadelphia Police Department, all first responders, local volunteers, community organizations, and media outlets, as well as everyone who worked tirelessly to help find our daughter. Although the outcome is one no parent should ever have to face, we remain thankful for the unity, leadership, and love that surrounded us through it all. As we continue to grieve, our family now seeks justice for Kada. We place our full trust in the Philadelphia Police Department and the Philadelphia District Attorney's Office to ensure that the truth is revealed and that those responsible are held accountable to the fullest extent of the law. Please honor Kada's memory by showing kindness and care to one another, just as she did every day of her life. With love, strength, and gratitude, the family of Kada Scott.
Real tough spot for Kada Scott's family, and everyone obviously thinking about them tonight and have throughout all of this. But something in the statement that they made there, that they have trust in this DA. Should they have trust in this DA? I want you to take a listen to what happened in the prior press conference and the most recent press conference, where they're talking about Keon King, the suspect, and his past and how he seemingly slipped through the cracks. Take a listen.
There's been some discussion about a prior case involving defendant Keon King, involving a different victim, a case that ended at the preliminary hearing. And there has been discussion about some of the events that occurred there. There is no doubt that there's a list of people in this office, outside of this office, and no, it doesn't matter who they are, but there's a list of people who made a lot of good decisions and a couple decisions that could have been made better, that could have been better, right? There's certainly that has been discussed. But we also can't skip over some of the systemic issues here that are not small. This is a case in which, in the prior matter, we requested $1 million bail, $1 million minus $1 bail, and we did not get it. We don't set bail, judges do. The bail was set at $200,000. Why? Well, probably because the commissioner who set the bail probably imagined that was enough to hold Keon King in custody. It wasn't. Keon King had access to a lot of money. And so he paid $20,000 bail almost immediately and was out of custody as a consequence of that, right? This is the problem with cash bail. This is what we've been talking about for a long time. It's not just whether or not he's in custody immediately. It's also what is the situation of a victim who has to go to court, a victim of domestic violence who has to go to court, knowing that the defendant will walk out the same door she came in. What is the situation? How likely is that victim to come to court if that victim knows that that victim is dealing with a profoundly dangerous, profoundly violent person? And we all know the answer. That victim is more likely to walk in the door of the courthouse and testify if that victim knows that the defendant can't walk out right behind her if he's locked up. Well, he wasn't locked up here. And so, sadly, what happened was there were two court dates, at the first of which the judge announced that it must be tried next time. And the victim did not arrive on both of those occasions. An eyewitness did not arrive on both of those occasions. I don't say that to say that's the whole story, but it's not, but it is part of the story. And it is a part of the story that would be remedied if we got away from this, frankly, nutty notion that bail is a good way to deal with these situations. Someone profoundly dangerous should be held. I don't care if they've got a lot of money. Someone who's not dangerous at all shouldn't be held. I don't care if they're poor. That should have nothing to do with this. Money should be divorced from determining who stays in custody, as has been done in the District of Columbia and many other states. It is a successful system. Now, without pointing a finger at any individual, I am pointing a finger at the cash bail system because its role in this is, frankly, very problematic. I also want you to know that there has been, and there continues to be, extensive victim support and outreach to the victim in the first case. That's just a fact. And we will continue to do that. Some of it I cannot even speak about because it would be inappropriate for me to talk about some of the measures that this office has engaged in for her protection. This is a situation in which there were actually two witnesses. There was a complainant. There was an eyewitness. There were good efforts to have the case prepared, to contact them, to speak to them. There were good efforts to subpoena them. Nothing is perfect in this life, but that was all handled well. The case was marked must be tried by a judge at the first listing when these witnesses did not appear. Neither one of them appeared for either one of these two listings. That is a judicial decision. It is not our decision. And then on the second occasion, when these two witnesses did not appear again, the attorney who was handling this case was faced with having the case either thrown out or withdrawn. There are certain strategic reasons why it can be better to have it withdrawn. But understand, when a judge of a particular level, and here it's the municipal court, rules that this is a must-be-tried case, that, under the law as it exists, requires the second judge to throw it out if the case is not ready to be tried. As we have indicated before, I do believe that there is a way this could have been presented without those witnesses. The buck stops here. That is on me, that it was not handled in that fashion. But I also believe, as I've said before, that it's a tough situation, especially in domestic cases, when you have a defendant out of custody who's going to come in and out of the courthouse doors just like those witnesses.
He's pointing the finger. Amazing. All right, I'll start with Darnell. Darnell, should they trust this DA?
It sounds like he's waffling a bit. So he says the buck stops here, and he said there could have been a way to try this case even with the missing witness. He didn't go as far as to say how or apologize for not doing it, but it sounds like he's pointing the finger at the judges of the world and the cash bail system of the world, but not at himself. So he's saying, oops, I'm sorry. the system failed, but not saying that he failed the system. So when you hear that, if I was these parents, I wouldn't have too much trust, and the spotlight should stay on him.
Vinny, I'm going to jump in. I think a lot of people in Philadelphia are upset with him, and but it's not only here. There are other. We talk about cases like this all the time on court TV, where someone has committed a crime in the past or been charged with a crime. They're out on bail, or charges were dismissed, and they're out again, and do something even more violent. And this is just unfortunately another instance of that. So it's not just a problem here; it's a problem everywhere. And how do we keep these violent people behind bars? You have a chance to do it, and then somehow the system allows them to get out, and that's what we need to deal with better.
Well, as I recall, our system of justice requires the right of the defendant to be able to stand and face his accuser. So if a witness doesn't show up, if the victim doesn't show up, how is a prosecutor supposed to prosecute the case? You can't, okay? Now, whether or not you can send a police officer to grab the person from their house and say, you're coming with me, and you're going to be sitting there, and you're going to be at this trial, they're not going to cooperate with you, first of all. Second of all, I don't even know if you're allowed to do that. Third of all, if you threaten the victim with, well, then we're going to get you for filing a false police report, so then you're beating up a victim. So what's a prosecutor supposed to do under those circumstances? I mean, you're in a very bad position. If the judge says try or dismiss, and you don't have your ducks in a row, and you don't have your people there, and you don't have your victim, and you don't have your witnesses, the police officer comes there afterwards, not during. And the police officer can testify as to what he or she saw as to the victim, and maybe even what he or she heard from the defendant, but not what the victim told him or her. That's not going to come in. Okay? That's hearsay. And that situation is a problem.
Al, it may be enough. It might be enough.
I can interrupt you. You keep quiet for a minute, please. Quiet. Silencio.
You've been talking a lot, so.
Okay?
Wow.
The circumstances are that a prosecutor cannot. You've never prosecuted a case in your life, okay? So, Jennifer, if you've prosecuted a couple of cases, then come talk to me. Vinny and I did. Okay, it's very difficult.
But Al, I disagree with you. I disorgree with you, Al.
You can disagree all you want, but the bottom line is
no. The bottom line is you got to, number one, you've got a video of. You've got a videotape of it. He admitted he didn't even subpoena the witnesses. They didn't even subpoena the witnesses.
Come on. That's a huge problem.
What kind of prosecutor goes, yeah, I'm ready for trial. I just forgot to send my subpoenas. Give me a break. That's absurd.
But the bottom line is
that's absurd.
You don't have a situation. That's a situation. Okay, that's a problem.
That's a situation created by the prosecutor himself.
But how can you keep the person there if you don't have your witnesses?
It's called a subpoena.
How are you going to be able to keep them there without that?
It's called a subpoena. Like we've never had a case like this before.
But hey, Vin, have you subpoenaed witnesses and they didn't show up? Then what do? You're going to
they don't show up the first time. The second time, you make sure they're there.
It doesn't work.
Al, the confrontation clause says you have a right, again, to confront your witness. But we know that we try cases, and especially in domestics. Before, in the old days, if the wife says, I want him home, he pays the bills, they drop the case. Now, they hardly ever do that because we know that the women in these cases will have this buyer's remorse. And so the prosecution now in DV cases, they go the extra mile to prosecute the case.
This is not unusual stuff for a DV case. This is standard operating procedure in domestic violence cases. Okay.